Many thanks, dear Winfried, for this great overview. It was really great presentation, and I think all those who were a bit sleepy have definitely waken up in the meantime listening to his arguments. Now I have the greatest pleasure to invite Christian Svanberg from Denmark. Yeah, Christian, please join us. Christian was involved, please, in the negotiation during the drafting of the GDPR. How many years ago, Christian? It was 2012. Together with Winfried, and we have a similar company joining us virtually from London. I hope that Elisabeth is with us, Elisabeth Stafford, who is, hi Elisabeth. Elisabeth is currently in charge of the consultation that is going on in the UK. I'm also having on the screen Eline Chivot, who unfortunately couldn't join us because of the travel ban. She is a senior expert at the European People's Party. Hello, Eline. And
hello.
Last but not least, we have a representative from the European Commission, Karolina Mojzesowicz, who is going to tell us and confront the arguments that we have heard today in the morning by Winfried. Great to have you today in the morning. Maybe let's start with a small reflection. Christian, what are your first thoughts listening to Winfried?
Yes. Well, my first thought is that I've worked in data protection for 19 years, and I think Winfried's presentation now is the most coherent and well-founded criticism of not just the GDPR. I think that's an important point to make, but data protection law in Europe in general. I think just to add to all the points he made, and I basically share all of them, all the criticisms. I think an important reason for why this is the case, that we have these arguments against the GDPR's current model, is that to a large extent, the GDPR copied what was in the previous directive, which was originally proposed in 1990 and adopted in 1995. And if you draw the conclusions from those dates to say that the answer for the next 20 years on how we should govern a digital society, processing of personal data in massive amounts, the invention of the internet and all the innovations that have taken place since 1990, to say that the model for regulation someone came up with in 1990 is fundamentally still the same we want to apply today, either means, one, that was a brilliant model that really was future-proof, or maybe that it wasn't. I think we're arguing that it wasn't. To say that you can assume that everything that someone does with personal data should stand a test of legality, even if it's in private sector, public sector, and that those rules could be put into one single document and applied. And then also, I think that's an important point, made subject to criminal penalty if you fail to comply with these rules that are so general that almost no one can give you a clear answer beforehand. And then the final point I was saying, that's one of the final points that Winfried made, was that at the end of the day, the actors that we wanted to control or regulate to a large extent with this was the big tech companies. When we were negotiating the GDPR, it was a daily occurrence that when a new provision was being tabled or described by the Commission, they would say, this is necessary to confront the practices of Google and Facebook, etc. I just have to say, I think they're doing fine right now. I don't think we've managed to actually regulate them and contain them in any way. And I think that's why we're seeing new regulation coming along. But we can't just leave this on the table. I think we need to have a discussion. I share your skepticism about whether or not a GDPR reform is likely, but the Commission can probably answer that. I think I know the answer. But I think we need to be open to say, okay, this was an important legislative act, but it definitely wasn't the solution to everything.
Many thanks, Christian. Maybe we continue with Eline. Dear Eline, what could be the adjustment to some provisions of the GDPR that would make a difference? And also, maybe you could reflect on Winfried's thoughts as well.
Yeah, thank you very much. I hope you can hear me well. I think there's a little echo for me, but just let me know if it's difficult. So thank you very much for, first of all, for allowing us to join remotely this time, and for the Konrad-Adenauer Foundation, and of course to you, Pencho, for having me. I really enjoyed Winfried's talk and the interesting analogies that he's used, and as I actually heard and learned a few things that I had not come across yet. I very much like the part discussing the understanding of what data is and its value as well. And indeed that our strong focus on privacy, which is an important value, shouldn't overlook the importance of other critical values and dimensions that should be in the balance, like security, competitiveness, which is about economic security in the end. But I'd like to offer some comments to complement his very thorough analysis. I think we indeed haven't made it yet to achieving this one continent, one law, or sort of becoming a data Switzerland, which can explain why the EU is pushing ahead with other policies like the data strategy for industrial data in particular, which may be indirectly recognizing that we haven't managed to harness the potential of personal data with the GDPR. So we needed something more or something else. At the EPP, there's more and more conversation about how we can address the GDPR's limitation. There's been this report by MEP Axel Voss, who took a brave stance looking at a law that he himself crafted a while ago. But revising the GDPR is not actually an argument that big tech makes anymore, that it should be revised. They have the money for the lawyers. And it's good they've been regulated, but the argument that's often dismissed, because it would be a big tech argument, is the fact that it is limiting our SMEs and our startups' agility. If you talk to data scientists, not lobbyists, not lawyers, people who are not in Brussels, people that are not ideologists, but work with data every day, they can tell you, we sat down for hours discussing whether we were in the clear with the GDPR, whether we were compliant, because we were trying to do things with pseudonymization, for instance, and they still couldn't figure it out. So I think another thing that's interesting, I mentioned the data strategy, is GDPR can limit what the EU is trying to do now, and the policies that we're trying to implement. The data strategy, and especially in the DGA and the creation of data spaces, encourages the sharing of data. Industrial data, but when you talk about data space like in healthcare or in the financial space, inevitably you will have to deal with non-personal and personal data and sensitive data. That means a lot of companies are going to have to do an arbitrage between what one law limits what you can do, collecting personal data in certain ways, while at the same time wanting to sort of participate in this data economy, which encourages you to share data. Now, of course, there's few things that I could add, that the law took a while for some countries to implement to GDPR, to incorporate it in their national laws. There's been there's a difficult situation still for various DPAs in terms of their resources, their performance, the effectiveness. Monitoring the application of the GDPR has proven difficult. In fact, I think there's a complaint that's been filed earlier this week, because saying the Commission hasn't been using the right data or doesn't have the appropriate indicators to be able to monitor how the law is implemented. Also saying that the Irish DPA isn't actually delivering, and there's perhaps an impatience also regarding DPAs, especially in Ireland, a call for them to wrap up their investigations more quickly, to really come up with bigger fines for companies. I think the Parliament even called for infringement proceedings against governments that had failed to provide regulators with sufficient resources to fulfill their duties. Now, in a nutshell, delays, insufficient enforcement also have to do with the complexity of the law. There's also a problem of cooperation between DPAs, mistrust between regulators that's been highlighted, cultural, language differences, outdated information exchange systems, and of course diverging legal systems. Now, again, I think this was mentioned, this is also costly in terms of innovation for businesses. There's a survey of Bitkom in which close to 80% of respondents, which were German businesses, said that innovation projects have failed due to concrete requirements of the GDPR. So as you probably all know, the EDPS will host a conference to address some of these issues related to the GDPR, but I'm not sure we can expect radical changes. But there is a recognition that we need a stronger common framework to tackle the digital economy. Companies and some policymakers want to see an increased standardization of regulation at the European level. But many still think it's not the time to be thinking about whether the GDPR should be amended. But the wait and see approach is just not going to work in the digital age, because technologies are moving faster than our ability to legislate. So hopefully there will be some progress made in the conversation in the margins, but I doubt that it will address some of the critical issues that including MEP Axel Voss has identified. So I'm happy to get back to later what we could do to revise the law, but I think I should probably leave the floor to my fellow panelists. Thank you.
Many thanks, dear Eline, and thanks for reminding us to the paper of Axel Voss, who really, I think, made good remarks where should we start when it comes to the GDPR and regarding reform points. Now, I would like to welcome Elisabeth Stafford. Elisabeth, the consultation in the UK is of special interest to all of us. We would like to learn a bit more for the reasons for the consultation, and maybe exclusively to find out what was the feedback that the UK government has received. Where do you see room for adjustment? And what do you think? Could it jeopardize the data sharing agreement with the Commission, maybe?
Thanks. Gosh, that's quite a lot of things to cover. Hello, everyone. My name's Elisabeth Stafford, and I work on data protection reform in the UK. It's 8 AM here, so Winfried's speech definitely woke me up, especially the mention of GDPR heresy. Don't think I'm a GDPR heretic here. I worked on the negotiations of the GDPR along with Winfried, Christian, and even Karolina for a short time in the Commission team. I think the GDPR has been a success story in terms of the impact it's had on data protection rights and awareness, but as Winfried said, it's not been a perfect instrument. There were various pressures and factors at the time. For instance, 4 years that we had wasn't actually enough to get into detail on a lot of very complex issues that affect different diverse aspects of our society and economy. We were also, as Winfried said, shooting at a moving target. Technology was developing and growing as we were drafting and debating. We also had, I think, the challenge of thinking about the need for uniformity in the single market. So not just what's the impact on data subject rights, what's the impact on controllers, but what's the impact on uniformity. And that can be difficult when there's many different opinions in member states at the time. I think considering those factors, it probably, I think, was the best it could have been at the time. It was a great achievement. In fact, in the UK, we did vote for it and we brought it into our law. I think now that we're 5 years on, it's definitely not heresy to look at what the impact of some of our choices were at the time when we drafted and agreed the GDPR, to look at, is it indeed technologically neutral? I think during the talks, there was quite pressure to reach compromise. So a lot of important information ended up being put in, say, recitals. Winfried mentioned the purpose limitation principle. The exemption to that is contained only in the recitals, not in the operative text. And what's the impact on researchers there? I think it's something to celebrate, but it's not beyond criticism. And there's a number of issues that Winfried mentioned that, of course, we've been thinking in the context of our reform. So as you mentioned, we published a consultation in September. We closed it a couple of Fridays ago. It contained a number of proposals for driving innovation, particularly in the research space. It looked at lessons learned from the COVID pandemic. What ways could we improve the GDPR there? And it looked also at accountability. Winfried mentioned sort of a one-size-fits-all approach in the GDPR. So we're looking in particular at the accountability framework and seeing, are there ways that we could achieve the same outcome, achieve the same level of protection, perhaps through less prescriptive processes? And can we give the controllers space to achieve the same outcome in their own way? I think if I want to describe sort of our aim and our, sort of our consultation in one word, well, it'd definitely be long. It's 146 pages, but the word I'd like to pick would be thought-provoking. We're asking people to reflect on a number of questions. Firstly, as I mentioned, can we achieve the same level of protection through different means? And secondly, we're often asking ourselves, and indeed the public, what does this mean? So Winfried mentioned a lot of uncertainty in the GDPR, legal uncertainty 5 years in. And we're wondering, what does this provision, this requirement mean? What would a regulator say? What would a court say? And that's not good for data subjects, it's not good for controllers. So we're asking ourselves and the public, are these problems of uncertainty really causing issues? Can we solve them through legislation? Can we clarify them? What are the risks and benefits? I think a lot of those sort of problems or lack of clarity are ones that maybe Winfried already identified. So purpose limitation, as I said before. We've spoken to many sort of data controllers, data subjects, privacy activists, and there are quite divergent views on when you can do further processing, especially for research. Indeed, what is further processing? We've seen some sort of uncertainty in the UK around university research. What is the legal basis? Winfried mentioned that you need to find a law supporting that public interest to use the public interest basis. If you're a university, is your founding charter, your statute there sufficient? Does it have to mention research? That's a question that we've been asked before by universities. The COVID pandemic also has been driving our reform. I think, again, Winfried mentioned that that's shown up some possible, again, uncertainties or problems in the GDPR that could be resolved. We had a number of telecoms companies who were asked to deliver messaging about the COVID pandemic, about the requirements. Again, there was concern, what's the lawful basis for this? Can they use legitimate interest? How do they do the balancing test when it's not actually their purpose? They're being asked to do this. Can they then use the public interest? Are they exercising official authority? Does it count as their public task, even though it's actually the government's public task? So there was, I think, quite a lot of uncertainty about what the proper lawful basis was there, but everyone was in agreement that it was in the public interest for that processing to take place. Yet there's still uncertainty about how it can be lawful in the GDPR. So I think that and various other issues, we really wanted to get people thinking on these problems and solutions, because ultimately confusion doesn't benefit anyone. It's not good for data subjects. It's not good for controllers who won't want to have to wait for a test case. I think in terms of the consultation, I have to be careful about sort of saying what kind of responses we've got. We have got 3,000, and it's a bit too early to say anything yet. So it's 3,000 responses for us to read through. We also had 40 round tables where there was quite a number of themes. Some of them did pick up on issues Winfried mentioned. We were also asked about what would be the impact of our reforms on data subjects, and to what extent should we actually legislate to correct any of these issues? Is guidance a better alternative? So we have to read through all of those 3,000 responses. That will take quite some time, and I can't say until we've done this whether there will indeed be a reform bill, but I can say with certainty that there will be a government response, and we're going to publish that in spring 2022. Lastly, I think you asked about adequacy. That's indeed been a question that we've had throughout the roundtables and the consultation. I think it's important to recognise that even the European Commission themselves have said that when they're doing adequacy assessments, the third country's law does not have to be a carbon copy of the GDPR. We currently do actually have a carbon copy. We brought the GDPR into our law, made almost no changes other than relabeling it the UK GDPR. But yes, it doesn't have to be a carbon copy forever. And indeed, the current range of adequate countries show quite a sort of diverse, different range of laws. And I think I use the word difference. I think divergence certainly probably isn't the right word here. When I think of divergence, I think of us going in different directions, and we don't see ourselves as going in the different direction of the EU GDPR at all. We see this more as clarifying various matters. We're trying to reach the same outcome, the same level of protection through different means. We're seeking to clarify things that are uncertain in the text for the benefit of data subjects and controllers. But we're still wanting to build on the same foundation, the same data subject rights, principles, enforcement mechanisms, because there's the very same principles that have indeed made the GDPR such a success. It is a world-leading regulation at the moment. But as I said, and I think as Winfried's presentation showed, it's not without faults. There are areas that could be looked at, and that's what we're hoping to do with our reform.
Many thanks, Elisabeth. You made great overview, and now I think it's much more clear why are you doing this and what we may expect in the coming months. I'm glad that also we have a representative from the European Commission with us virtually today, dear Karolina. Obviously, no one wants to put in questions the relevance of the GDPR. However, there is obviously some room for improvements. Yesterday, we heard also by Johnny Ryan that enforcement matters. How do you comment the presentation of Winfried and the thoughts of Christian and Eline and Elisabeth, please?
Good morning, everybody. And thank you very much for having me here. I'm very happy to indeed address at least some of the points which were made in this so entertaining, let me call it, presentation. Well, just to start with, and I think that I have rarely seen and heard, even not only in the morning, but throughout the day, so many simply wrong propositions. To start with, one size fits all. It's completely not true. It's just wrong. GDPR is a principle-based legislation. Yeah. And this is precisely the reason Winfried made afterwards the comments that there are still so many preliminary rulings and the needs to clarify the application of certain rules. Why does this principle-based approach help us so much? Because it provides for scalability of the obligations. It provides for more that the controllers should impose on themselves, more obligations depending on the risk the processing signifies to individuals. So precisely no one fits all approach, precisely scalability, precisely dependence on the risks, and precisely accountability principle of which other speakers were talking. Then another point, encroachment of private autonomy. We do not need the law because we have already fundamental right. Well, this is very entertaining because I wouldn't know how to enforce a fundamental right if I would not have been equipped with enforceable rights in the GDPR in order to enforce my fundamental right. That every processing provides for, or every processing triggers information obligations. This is precisely therefore so that my fundamental right can be enforced, that I know what's going on with my data. Now, in context with this goes this allegation that it's so individualized. Well, it's enough to have a look in the GDPR recital 4. The processing of personal data should be designed to serve mankind. The right to protection of personal data is not an absolute right, but must be considered to its function in society and balanced against other fundamental rights. This already shows how much the GDPR provides for calibrations between the individual right to have his, her personal data protected, and to which extent this processing serves the public interest. Well, I could go on, and just to start with this really remarks concerning the definitions and that we have anonymized data not protected under the GDPR, and that because what happens if this anonymous data is being rendered personal data? Well, if it's personal data, then it's under the GDPR. If it's anonymous data, then it does not allow to identify an individual, and therefore it does not fall under the Charter and the fundamental right of freedom right to protection of personal data. Finally, privacy not mentioned in the GDPR? No, because the GDPR is about protection of about a different fundamental right, protection of personal data and not privacy. About privacy, Winfried, it's e-privacy directive and regulation. Well, so much because I think I can even not cover all the imbalance of power. Since when was the GDPR supposed to cover aspects which are covered under consumer law and competition law? The GDPR is about giving the control back to individuals, to data subjects, with what is going on with their fundamental data, with their personal data. Their right to protect their fundamental right and putting it in context of function of this right in the society. It is open. It is not one size fits all. The controller should assess the risk the processing they undertake is presenting and impose on themselves more obligations if they have a processing which can have more impact on the individual. That the size of that undertaking does not matter was extensively discussed in the council. Very big undertakings can have a very non-intrusive processing, and a very small undertakings which are in processing, for example, very sensitive DNA data, although very small, will have very high obligations, because what they do and when they do it, if this goes wrong, can have very important impact to the individuals. So I think this would be so much to some of the most striking points I found in the presentation. Now, I was a little bit surprised also by the comments I've heard here that and also from Eline. So, and I hear that. So, what finally are we complaining about? About the law or the lack of enforcement of this law? Yeah, because I'm a little bit lost. I'm a little bit lost there. That the enforcement takes some time. Indeed, we are speaking about very complex cases and cases which require very far-reaching investigations. We as the Commission, we have experience with such cases because we deal with this kind of undertakings in the competition area, and these investigations do take time. We had effects of the enforcement actions of various data protection authorities during the summer, and we have seen very important enforcement actions, including fines during the summer. Now, again, because I think this is also something to what Christian referred. The GDPR is not about reversing the imbalance of power. The GDPR is not about potential, if proven, or abuses of dominant position. It's not Article 102. The GDPR has a different function. And it's the reason the competition law, consumer protection law, and the GDPR, data protection legislation, are complementing each other and not replacing each other. As broad the GDPR is and as principle-based it is, it's not about rebalancing of powers of different different undertakings. It's ensuring that when personal data is being processed, this data is processed legally. What else? All the comments made and the need, the further, let me call it specification or legislation which the Commission proposes in the area of DMA, DSA, DGA. Well, precisely, we are providing for very targeted solutions in order to address other aspects. DMA is about fairness in markets. Yeah? So DAA addresses the imbalance of powers. All this, and here all the three instruments which I mentioned, are based and embrace the principles which are provided for in the GDPR. They all refer to the GDPR. They all refer to the concepts established in the GDPR. And if at all, they build on the solutions already provided for in the GDPR. Now, very shortly to Elisabeth's statement. So again, it's very nice that somebody from the UK comes and explains us that we have a success story come on the GDPR. Thank you very much, Elisabeth, because it seems that it's, here we had some other voices. Indeed, as far as awareness, as possibility to enforce this right, we are sure, also as far as establishment standards throughout the world. Now, some reflections upon what is going on now in the UK and how do we see it. So we observed, of course, with a lot of interest this consultation. And the consultation is really a very diverging bag with different thoughts, which can lead to very different solutions, beginning with providing for more guidelines or leading to indeed legislative proposals. Of course, as you said, and I think it was a question a little bit raised before, the whole question for us, should this materialize, should this concepts be endorsed? The question is to which extent it would significantly impact the level of protection provided by the UK. Of course, this is the UK's sovereign decision to decide whether the businesses should now comply with two sets of legislation. We hear more and more voices that it's just adding on compliance costs and adding on the red tape, but well, I will leave it there. Now, the elements on which there were a variety of elements on which we had already some discussions, but indeed the question of the independence of the ICO is a very interesting one. And here I'm drawing attention to the comments made by the ICO itself. And going back to the comments we had about enforcement and so on, I suppose that it will be very interesting and important to everybody, because the Data Protection Authority should not only be equipped with sufficient amount of resources, and we've heard this call from the European Parliament, and we engaged in certain actions with the member states. As this call is concerned, but this DPA should be also fully independent. Concerning, I was not sure to be able to follow the comments you made on the legitimate interest, because the legitimate interest as provided for in the GDPR allows the controller to take into account the interest of the third party. For somebody as knowledgeable in data protection law, you would know that already the Working Party 29 and now the EDPB works on additional guidelines embraced very much this idea of processing, which undertaking by the controller, which pursues, which takes into account the interest of a third party. And the guidelines provide for very interesting examples in this respect. I'm here referring, for example, to the possibility to process personal data as far as the protection of children for various abuses is concerned, or for some kind of cooperation with law enforcement authorities. Let me see, because there were so many interesting and entertaining thoughts that I would like to maybe
Dear Karolina, maybe I have a suggestion.
Yeah.
Since I would enjoy listening to you the whole day, and I think it's
Thank
not,
you very much.
I think it's not appropriate to have 10 minutes for such a debate, but keeping in mind that we have a call with the Digital Minister of Taiwan, Audrey Tang, my suggestion is to continue the discussion right after maybe the call with Gary Davis and during the presentation of Johnny Ryan in the afternoon. And I think we have enough arguments for short reaction to Winfried and Christian, and then we have to close the discussion. But I really appreciated your words. We wanted polemic debate, and this is what we got. And I'm really sorry that you couldn't join us in Berlin, but there will be enough opportunities to invite you and to come and to visit us in person. Would you agree with that?
Yes, of course.
Many thanks.
In your hands.
Many thanks. So please, Winfried, we have 10 minutes, and let's somehow sum up the discussion.
Yeah, I will keep it really briefly. First of all, I would like to say that I appreciate that we are sitting in this round together, which we did years ago when we were negotiating the GDPR. So Christian, Karolina, and Elisabeth were there, and we had maybe the same discussions in these times. Just a short reaction to 3 points. I agree completely with Karolina, not surprisingly. In one point, the GDPR is not about informational asymmetry. I was reacting with this point to a large fraction of the data protection people in Germany. There are many of them who say it is about informational asymmetry. And if you look into the history of data protection law, when it developed in the 1970s in Germany, it was about the relationship between state and citizen. And of course, one idea was that automated data processing by the state is dangerous for the citizens, and therefore the idea of data protection law developed. So one of the basic ideas was to deal with this informational asymmetry between state and citizen. And nowadays, the data protection law applies not only in this direction, but also between citizens. And that is my second point. When I'm talking about individual autonomy, I'm talking about the blogger, the street photographer, I'm talking about the researcher, and I'm talking about the artist. All of them are using their fundamental rights when they are processing personal data. If I'm taking a photo in the street, I'm a street photographer, I'm within the scope of the GDPR. And I think that should not be the case. And in Germany, we have data protection authorities who say even taking photos, not publishing them in the internet, but even taking photos of strangers in the street is forbidden under GDPR. And these are the unintended consequences. And I would probably, Karolina, you would agree with me that this should not be forbidden under the GDPR, but these are the consequences of the law, even if it is interpreted in the wrong way. Last point, scalability, calibration. Yes, you are right. We have the risk-based approach in the GDPR, but not the obligations are risk-based. Not the obligations can be calibrated. The means to fulfill the obligations can be calibrated. But
I disagree there, I have to say.
if you count the obligations, you have 68, I would say. Maybe it's only 50, depending on how you count. But the obligations is you have to search for a legal basis, you have to inform the data subject, you have to document, and so on and so on. And these obligations are not risk-based. They have to be fulfilled. Only the measures with what you fulfill the obligations are risk-based.
Christine, your final
I disagree there, yeah. I will just say that, yeah.
Your final remarks. What was the intention when you drafted the GDPR when it comes to enforcement? You also could listen to Karolina, maybe to sum up in a minute or two.
No, yeah, I'll keep it brief. So I don't know if I'll get around all aspects of your question, but I think the intention was definitely that there would be something that addressed the technological development that everyone had observed, made it necessary. Society was changing, and the rules needed to be updated. But I think to defend the observation that the GDPR is, in fact, one size fits all, I would say we just need to go back to the motivation by the Commission, by Viviane Reding, who was the Commissioner back then for Justice, the godmother of the GDPR, if you will, and her clarion call was one continent, one law. And that is just another way of saying.
It's a completely different idea. It's one law, one interpretation of the law, but it does not mean one size fits all. Accountability, risk-based approach. This is what the GDPR is about.
But still, I think some of us are lawyers and have worked both as private counsels.
This is a completely different idea. When that it's a one interpretation, and it's precisely what Eline was saying, that we want to have one interpretation of the law. What she was complaining about, what she was alleging is that we do not have sufficient uniformity in the application, in the enforcement. Yeah,
well, I think we're making the point.
Scalability. Are you not telling me, Christian, that there is no scalability in the GDPR?
No, I think scalability of law is an absurdity. You don't scale law.
It's not a scalability of law. It's a scalability of obligations. Are we now having really a discussion about whether the GDPR is a principle-based regulation, which is technologically neutral and embraces variety of businesses and graduates in the obligation, a part of the very basic one, like legal basis and information rights, so that I know that my data is processed. As far as technical and organizational measures, safeguards, as far as all these elements are concerned, the GDPR sends one message to the controller. Check what you are doing, and if it has a lot of risks, you have to impose on yourself more obligations. This is the scalability about which I'm talking.
Yeah, but I still think that if you claim that, and I think I agree that is what the GDPR contains. It does contain principles, and it's principle-based, and it has these different assessments, but that's the problem. That's the problem by design.
Well, but then what?
No, please let me finish.
Let me finish.
Otherwise
there is,
we'll never finish.
One or the other.
No, but I can have my opinion, and my opinion is I think that is a problem. And I will also argue if we want to look forward and see how do we solve this going forward. I think we need to recognize what went wrong, and to make another bold statement to make everyone know what to do. I would say that some of the dysfunction that we are claiming, at least, is in the GDPR, is by design. And by that I meant that because the Commission insisted on one regulation for the entire public sector, the entire private sector, with 99 articles and all these obligations, a process began immediately in 2012, whereby carve-outs was added, balancing was added. A lot of the things that Winfried spoke about were added during the negotiations in order to give a surety to politicians, to companies, to lobbyists, that what they were dealing with in their everyday life would still be allowed. Because if you make it principle-based, no one knows what is exactly the rule that applies to them. So that was sort of by design, done both by the governments, because they wanted to make sure that what they wanted to do was still legal, and by lobbyists. But anyway, I think it's not that this wasn't said out loud back then. In fact, I even had the pleasure of co-authoring an article on this in 2013 with Peter Blume, a very well-known European forerunner researcher, professor, You can all still go read it. It was published by the Cambridge Yearbook of European Legal Studies, and it's called The Illusion of Harmonization.
Having in mind that the digital minister of Taiwan is online, I would just kindly ask you, dear Elisabeth, Eline, and Karolina, with just one sentence to close this session. And I'm kindly inviting you to follow the discussion and also to be involved in the discussion in the late afternoon with Johnny Ryan. So please, Eline, your final sum-up comments.
Thank you, Pencho. I really enjoyed the conversation. I think it's nice to see some disagreement in Brussels. It's often consensus-based. So, and thanks, Karolina, for pointing out what you thought were limitations of my arguments. I think there's different schools of thoughts that point to different problems and want to see different types of progress. On the one hand, something more future-proof, friendlier towards innovation, and allows more healthcare research, keeping in mind the recent examples with the pandemic, and others that want to see just more teeth and more fines, more credibility in enforcement, more coordination among the DPAs. I think, maybe the GDPR hasn't reached its potential yet, but definitely a discussion should start on how to adjust it with clearer definitions, more specific rules for different areas, adding more speed and flexibility, of course, without compromising our privacy and our standards. Thank you so much again to the Konrad-Adenauer Foundation and to you, Pencho, and to my fellow panelists. It was very interesting.
Dear Elisabeth, and your final remarks, please.
Thanks, and thank you to everyone. I think this was a very enjoyable, thought-provoking panel, especially Karolina's views. I think, I'd agree with Eline. The GDPR hasn't quite reached its full potential, but I think we can, sort of in the years to come, work on building on its successes and try to maybe bring more transparency for data subjects and certainty for data controllers. And we'll be thinking over these issues when we assess all our consultation responses. So look out for our future response in the new year and spring.
Many thanks. Dear Karolina, it's your pleasure and our pleasure to close the discussion.
Well, just maybe saying that with all the complaints I've heard today about the research, it's still nevertheless, we were able in the EU to have a very effective response as far as COVID or as far as possibility to process data for COVID combating purposes is concerned. And we do have solutions which are, on the one hand, GDPR compliant, and which allow us to travel across Europe with the same pass, which is recognized in all the member states. Now, I'm very happy that somebody from Singapore can listen maybe even to that, because we were able to have the take-up of this COVID pass just because the citizens trusted in the solution we offered. Yeah? Otherwise, people were not willing to have their personal data on such a sensitive matter processed. So, thank you very much. It was a pleasure.
Thank you very much to all of you. It was a great debate. I'm inviting you to continue the discussion maybe next year in person in Berlin. Hopefully, the COVID is going to leave us alone. Thank you very much.